Yes, I salute you all. Thanks for listening and thanks for watching. Like the video, subscribe and follow our channel basically. So today we are having a guest speaker, or our delighted guest, and is here to take us in a certain concepts in criminal law. Our dear guest, you are most welcome.
Thank you, Council Matalo Peter. Greetings to you all. Welcome to the YouTube channel Matalo Simon Peter. I'm by names of Council Mugisha, and today we are going to take you through the elements of criminal liability. So what you have to note that for someone to be held liable under criminal law, we have to look at two elements, whereby we have Acteus Reus and also Mensrea. But before we go to that, you have to know what is the purpose of this law, criminal law. Criminal law, I won't go deep into that, but we have some of the theories that we have put under for the instance of criminal law, whereby you have preventive theory, we have also deterrent theory. So for someone who wants to go deep into that, you have to look at in your free time. But right now we are going to look at two major elements under criminal law, whereby you have Acteus Reus and also Mensrea. So first of all, someone has to ask him or herself, what is Acteus Reus? Acteus Reus, this one involves a physical or external element of a criminal law or act, encompassing the conduct or consequences of someone, whereby here we look at the conduct of a defendant. So what did you do to make you liable for that offense? For example, if we are looking at rape, we shall look at the elements of the rape, and one of the valid elements is whereby did the defendant do the act of rape? Is he the actual person who did the rape? So Acteus Reus is one of the major elements, so whereby you cannot hold someone liable for the act he or she didn't do. So we shall look at Acteus Reus. That is the definition of Acteus Reus. And what is the essence of Acteus Reus? It is very simple. We have to put it into consideration because we shouldn't convict someone who is not liable for an act. So that is the physical element of criminal liability. So for someone under criminal law to establish Acteus Reus, we shall ensure that the defendant truly deserves the punishment, meaning that he did the act. And I'll also bring out an example of an offense of rape, whereby when they are examining the victim, we shall look at the point that if the victim can identify the defendant. So specifically we shall base our evidence on that to bring in the element of Acteus Reus. Then also under Acteus Reus, we shall look at their other elements, whereby we have voluntary act. So what is voluntary act? In an ordinary way, voluntary act, it's whereby someone, he or she did out of his or her own will. You get what I mean? So you did, you will be held liable, and we shall, under Acteus Reus, we shall have to establish a point of voluntary act. So you voluntarily acted out of your will. You get what I mean? So here, don't confuse this with Mensrea, but here we are looking at, did someone do the act out of his or her own will? So, and then under voluntary act, we have automatism. I think automatism, we shall define it under the Black's Law Dictionary. Under the Black's Law Dictionary, automatism occurs when the defendant performs a physical act but is unaware of what he or she is doing. So someone does the act but is unaware that the act is encompassing him to be criminally liable. But then also under criminal law, we shall look at the principle that ignorance of law is not a defense. So if you did something out of your will, it will act as a mitigation factor. There I will bring in we shall look at the the minor difference between what murder and what murder and manslaughter, whereby someone to be held liable for manslaughter, we have to establish the element of the intention. The element of intention, we shall base it on the what? There's what we call subsequent and what? Previous what? Conduct of a person. So for someone to be held liable, he won't be extremely exhausted. What? He won't be extremely sidelined from the what? From what the law said, but it will act as a what? A mitigation factor. So here we are looking at under automatism, we look at a concept of irresistible impulse. You're placed in a position whereby you cannot what? Resist it. And we shall also look at the case of Bratty versus Attorney General for Northern Ireland, whereby partial loss, it was considered as a what? A mitigation what? Factor, but not a what? A full defense. For what? For manslaughter. For what? For the offense of what? Murder. So he was held liable for what? For manslaughter. Then also under voluntary act, we have what we call...
Counsel, before, just on the issue of automatism, I wanted to just relate to a clear example in this essence. And the clear example could be automatism. You have explained it very clear and people have gotten it. And a good example even could be just relate to that. For example, you're driving a vehicle and the brakes actually fail to do what? Actually fail to work. So as the essence, or as what we are, as you are driving, the brakes have failed and you accidentally knock someone. So your act can be taken under automatism. Automatism can be a defense as well, because people can bring it to that my actions. Remember, hence we are talking about Acteus Reus, that physical element. Sometimes you may say that it was beyond my control. The brakes I was driving, they failed to work. So I couldn't control the consequence or what happened after.
So does it come, is it a complete defense? Or?
Automatism basically it is, as you hear that this is element of what? Criminal liability. You get automatism comes away, it can be twisted on accident. You get on the defense of accident. For you to bring, because accident is a complete defense. So your actions, which is the Acteus Reus, that external element, you may say that it came as a way of automatism.
It was
to make
out
it that
of your control. You couldn't control it.
Exactly, to make that defense clear, which is accident.
Okay, thanks for throwing more light on that. Then another what component under voluntary act, we have automatism. What do we mean by, we are done with that.
Reflex actions.
We are going to reflex actions. Reflex actions, it also, you can rate it to automatism. Also, in an ordinary way, it means that you also had no what? Control towards it. So that is reflex actions. Then the physical force. Physical force, what do we mean by this? So if you are to be held liable, where you also, you see voluntary act, we have three other components under voluntary act. We have automatism, we have reflex actions, and also we have what? Physical force. So if a defendant was placed in a place whereby he or she didn't have control over it, we shall what? Term it as a what? A physical force. Meaning that in the state you were in, you had what? You had no control. Meaning you had no what? You couldn't resist something from happening. So under that, when you're establishing the element of Acteus Reus, we shall look at voluntary act, and voluntary act we shall look at automatism, and we also look at reflex actions, and then also we look at that, the physical force. Were you influenced by someone? Were you influenced by a third party? So meaning that if you were influenced by someone, you had no control towards it. So it also what? Resulted into the what? The criminal liability.
Yeah, Counsel, there is the good case of Leicester versus Pearson. Leicester versus Pearson. Basically, under that case, it was under physical force. And in this essence, the person was was being charged of what? Was being charged of acts of murder. Basically, it was an accident. And now this is what court looked at to determine that there was a bit of the Acteus Reus. What they determined physical force. First of all, he was driving the car during the night. The traffic lights were not working. It was raining. The road was slippery. The zebra crossing wasn't clear, and the view from which the pedestrian was coming from, it was unclear. So court held that for any reasonable driver couldn't avoid such accident because of that physical force that was surrounding his actions.
And also to add on that case, we are looking at the circumstances that resulted into the accident. The road was slippery, the lights were off, meaning that it was also out of control. So that is what we call physical force. Then after that, also we are still under Acteus Reus, don't forget. Also under Acteus Reus, we shall look at another element, omission. What is omission? Omission, first of all, it is failure to act. Here we presume that as a reasonable person, you presume that you have to act towards something. So your failure to act and the results of it can result into what? For example, we look at arson. Arson. For example, under arson, we look at the case of Ara versus Miller. It is a 1983 case. And the facts for that case were that the defendant woke up one day, he was lighting a cigarette, then woke up one day, he found that the mattress had caught fire. Instead of doing something towards it to show that he was he could act as a reasonable person to prevent fire, instead he went to sleep. You get what I mean? Instead he went to sleep. Meaning that he failed to act as a reasonable person. When you fail to act under criminal law, you also liable under omission. So you have a duty to act as a reasonable person, because we also see it under the Penal Code Act, whereby everyone is presumed to be
under the Constitution, everyone is presumed to have a duty or the presumption of innocence.
Presumption of innocence.
Yeah, it is under Article 28, Clause 3A of the Constitution.
You're presumed to be innocent until you're proved guilty. So here we prove the element we are proving that you failed to act as a reasonable person. So he was liable for the offense of arson. So after that, from that element of omission, we are going to look at
the state of affairs.
The state of affairs. State of affairs we shall look at. Here we shall not look at the act of acting voluntarily. Here we are looking at the act whereby the concept of Acteus Reus that constituted the crime for the defendant, he failed to act, and the results prohibited into. And the results were prohibited by the law, meaning you are in the state whereby you haven't chosen to be in that state, but the state you're in will encompass you to be liable for that criminal act. Where, for example, we look at the state of affairs whereby someone is being found drunk on a public highway. The mere fact that a person is intoxicated and present on the highway constitutes of an offense without not needing any additional actions or omissions. So we also have offenses against fighting in a public. It is affray. You get, meaning that even though you were provoked by someone, you are in a state you can't control, meaning you have not voluntarily acted, but then the state of affairs will constitute a criminal liability. For example, affray. So that is simple as that is what we call state of affairs. So it will constitute to be criminally liable Then we also have causation. Causation refers to the requirement that the defendant conducts must have directly caused the criminal outcome. Here we looked at proximity. Proximity cause. The distance, proximity cause, meaning there was, you directly what? Into the what? The offense you acted upon. So this one, it aims to establish a link between the defendant's action and also the harmful what? Results. For example, when we look at the offense of murder, we shall look at causation. So whereby if it is established at that certain moment when the act occurred, you were within the premises. So we look at, so there you can't establish the defense of alibi that you were not within the what? The premises where the act occurred. So here the victim or any person who witnessed the act has to establish that at this time and these hours you were in this place. So we are looking at the what? The causation, the link between the defendant and also where it happened. So that is causation. And under causation, we look at the case of Ara versus Church. It is a 1966 case whereby the defendant had gone to his van with a woman for sexual purposes, and after that the guy mocked the woman that is what? He didn't have the ability to what? To give birth. Then the defendant panicked and wrongfully thinking that then the defendant panicked and wrongfully ended up knocking the what? The woman. And so the woman ended up dying. And under this, meaning that the defendant acted what? Unlawfully. But then we are looking at the link between the defendant and also at the scene of the crime. So that is causation. So this, he was held what? Liable. Also another element which we shouldn't leave out is also social harm. What is social harm? Social harm refers to the adverse impact that a defendant's action have on what? On an individual. Even though it is a society, it also an impact. What are the adverse impact? Social harm, here we mean that it indicates that the defendant's action are not only legally wrong but also harmful to others. So you can't say that if for example you look at the offense of grievous bodily harm, meaning that you have caused grievously bodily harm to someone, but not that it is only criminally wrong, but it is also what? Harm to that individual and also the what? The society. So that is what? Social harm. So example of Acteus rules, we have been relating it to some offenses. For example, rape, you can relate it to theft. And under theft, it involves conversion. Did you have the intent to convert someone's property into being yours? So you will be held what? Liable. So that is the element of what? Acteus rules. We are looking at the physical conduct of the what? Of the defendant. So we are done with...
So that is Acteus rules.
Acteus rules.
Yes, thank you very much. So
that is Acteus rules. We have tried to relate it to some cases, for example, rape, theft, grievously bodily harm, and also others. And now we are going to look at an element of mens rea. What do we mean by mens rea? Mens rea, it is a Latin word which means that what? We are looking at did someone have the mental mind?
The guilty mind.
Did someone have the guilty mind towards that an act? And for someone to be held liable, remember under criminal law, we are not, the case shall not be in your favor, in the favor of the state, if it is on probability. Here we are looking at the circumstances whereby the state has to prove beyond reasonable doubt. And beyond reasonable doubt, you have to bring out two elements. We have already looked at Acteus rules. So another element is mens rea. Did the defendant have the guilty mind towards doing something? And we shall also giving an example of manslaughter and also murder. They are whereby you look at section 170 and 171 of the Penal Code Act, and those sections, they clearly illustrate the differences, and the differences we shall base on the elements of murder and slaughter. The difference is simple. Between murder, we shall establish the element of intent, meaning that you had the intention to do what? To do the act. And the intention shall be based on the two things. We have subsequent and also previous conduct of the defendant. What did you do? Which weapon did you use? I can't use a pen and then you tell me that I was what? I had the intention of killing you. So here we shall look at if you had a spear, and which body part did you target? You look at, we shall, based on those what? Circumstances, then we shall establish the element of what? Mens rea. Then under mens rea, there are also several circumstances.
So those are the elements that prove mens rea, basically. You have talked about intention, which is one of the first elements that prove mens rea, basically. That for mens rea to be there, there must be intention. You must have the intention to do that certain what? Act. Crime, basically. So in that essence, that is the view there. So which other element that you are going on?
And also to throw more light on that, if you want to understand more about the element of mens rea, you look at the case of, it was the case of Ara versus Molani. It was a 1985 case. It is an appeal case. Then to establish also mens rea, you have to look at the foresight.
Even the case of Ara versus Molani, in this essence, we saw that this person killed his father, was his stepdad. But however, in this essence, he wanted to bring the defense of intoxication, but it failed. Reason being that the intoxication was voluntary. You know, under intoxication, you have what they call Dutch courage. You drink just to commit a crime.
You drink knowing that
I'm going to commit a crime. This. So in this essence, he drank, and as a result, he shot the dad to death. So the court held that his actions had the intention, basically. His drunkenness was to commit a crime. Yes, that is the case under what? Intention.
Also, what you have to know that for someone to be sidelined with this defense of intoxication, as we see under section 12 of the Penal Code Act, you have to establish that if you want to be sidelined, the intoxication, it does not have to be voluntary. It has to be involuntary, whereby someone intoxicated you unknowingly and you ended up doing what? An act. But in this case, he did it knowingly. From that, I think we shall go to the what? Foresight of the consequences.
Oh, foreseeability.
Foreseeability. So, the act you did, were you able to foresee that it could result to this? Because you can't tell me that you had a gun and also you targeted Matalo's head and you tell me you didn't have the intention. No, that's a lie. You can't tell me you had a spear and also you targeted someone's head and then he or she dies and you tell me you didn't have the intention. That's a lie. So, for example, cutting the persons on the vulnerable part of the body. You had a knife, instead of at least cutting the head, the leg, you ended up cutting what? Someone's head, and someone died, and you tell me you didn't have what? The intention. Yeah. For example, then we look at the case of DPP versus Smith. I think most of you are aware of this case, whereby the defendant was held liable for murder because it was, okay, the first element that was established in this case, they were considering grievous bodily harm. But grievous bodily harm, which part of the body did you target? So this person,
basically that case, to give you just a throwback even before, the case of DPP versus Smith, the element of foreseeability was this person, the police suspected that he was keeping some things some stolen things in the vehicle. So they came for inspection of the vehicle.
And they have a
but
right to
unfortunately, this person decided to do what? To just take off.
Take off, cleansing
So
the
as the police is carrying out its duty, the police officer bumped on the vehicle, but the other one just made it at a high speed.
at the high
So as a result, this officer lost stamina. So when he fell down, he fell into another vehicle that crushed him to death. So the element of foreseeability court said that the actions of you knowing that person is on your vehicle, you decide to overtake. It means that you can foresee that this person is going to fall and he may die.
Yeah.
So his death, his actions, the actions of the defendant or the accused in this case, he foresaw that what I'm doing, it is going to lead to the death of this officer.
He foresaw and also continued with the act.
Yes.
Meaning he did what? He had what? A guilty mind. So he was held liable for what?
For murder, basically.
For murder.
Yes.
Yeah, the offense was changed from grievous bodily harm to murder because there was that element. And also we have another element. We also have recklessness. Which circumstances were you reckless when you're doing the act? And the person is said to be acting with mensrea if he or she acted what? Recklessly. Under recklessness, we shall look at what is whereby you take a risk, but the risk is unjustified. What do we mean by unjustified risk? This is where a person foresees the possibility of the risk, but does not desire to occur, but proceeds. You proceed with an act. You have foreseen the act, but you proceed the what? So you're being what?
Reckless.
Reckless.
Actually,
So as
reckless
in-
is that you don't care
You don't
about
care
the
at all.
outcome, basically. You are doing something, but you are not bothered about the
So
outcome.
in this case of Smith, he didn't care about the what? The outcome. So he was ended up being what? Liable. For what? For that offense.
Yeah, we have the case of Regina versus Cunningham. The case of Regina versus Cunningham, this person sold a gas meter. But the essence that you have stolen a glass meter, you are leaving the gas to link. In this essence, you are endangering the life of the people in the house. So his actions were found to be reckless. That you have removed a gas meter from the gas is leaking. Which means for you, you are not bothered. Your actions you are doing out of what? Recklessness. That is the
Yes.
case of Regina versus Cunningham.
And also under recklessness, we look at the what? Was it subjective or objective? If it was subjective, you continued with the act. Then if it was objective, you also didn't mind what would result. So you under criminal law, you will be what? Held liable. And also we shall look at another component under mens rea, and that is negligence. So for someone to be held liable for an offense of negligence, we shall look at, did you have a duty of care? Did the defendant have a duty of care towards someone? For example, we look at an ordinary example whereby a parent or a guardian, you have to take care of the what? Of the child. So you have what?
You have a duty of care.
You have a duty of care. So to establish the component of negligence, we have to bring in that you have a duty of care. The defendant breached that duty. As a reasonable person, you breached that duty of care, and also
It led to damage and injury.
or grievously bodily harm or what? Or loss. So under that, and also it is the defendant who did what? Who breached that duty of care. So to establish the what? The offense of what? Of negligence. Negligence came about in that case of what? There is a Rock Lascars case of what? Dunok versus Stevenson. That's when it was what? Established. Whereby a third party did what? Sued for the what? For the snail that was in the what? Giant snail that was in the beer. Then the what? Was held liable. So you have a duty of care and you also breached that duty. So you will be held liable for the what? For the offense of what? Negligence. To throw more light, and if you want to read more about negligence, we will look at section from section 210 to 213 of the Penal Code Act. It has all those components.
So basically, there is that case of R versus Proctor, Gibbons and Proctor. These people, the accused person and his wife, they failed to feed a child. The child was 7 years because it was the man's child. You know this bias that he left the child with his wife. The wife, knowing that is not the mother of the child, they refused to feed the child, and the child died. So as a result, they were convicted for murder. Reason being that they acted negligently because they had the duty to take care of that child, of which they failed to fulfill the duty. So basically, that is the case that under criminal that they brought it under what? Negligence.
And under negligence. Thank you, counsel, for that case. So that's what we look at under negligence. That you had the duty of care, you breached that duty. So the duty, after breaching that duty, it resulted into what? So when these people failed to feed the what? The child.
The child starved
and then died, meaning they what? They breached that duty as the parents or guardians. So they breached that duty of care. And also, it was also seen in another case of Fagan versus MPC. Under that case, there was also what? Here they talked about Mensrea and Acteus rules at once, meaning that there was what? Criminal liability for the defendant. Then
that case of Fagan, the other one stepped on the officer's leg. When the officer asked to remove the tie on his leg, he refused. So the court held that the fact that the first instance of stepping, it was by accident. But the fact that he refused to remove the what? He continued
with the act.
It brought that element of mens rea.
Yeah.
And the surrounding the Acteus rules is that refusing to remove the cutter remained on the leg of the officer.
So that is also another way how courts have continued interpreting the what? This element. You continued with the act. So you can't pierce someone repeatedly, and you tell me you didn't have the what? The act. So the court also looks at that, the continuing act of the Acteus rules. So for the what? You continue doing an event repeatedly, meaning you'll be what? Held liable. So thanks for listening. I think we shall end there. We have fully digested the two valid elements of criminal liability, that is Acteus rules and also mens rea. Thank you.
So thank you for listening, and counsel, thank you for the time that you have given to us and the insights you have shown us in Acteus rules and mens rea. So our viewers, subscribe to the channel, like the videos, and comment where you feel that you want more light. But other than that, thank you for listening and thank you for watching. Thank you very much. Yeah, possible.